right, good morning, everybody. Welcome back. Happy New Year, and I say this with 100% sincerity. I'm very glad to see all of you, and looking forward to this session and working together and making some steady progress in a constructive way, and we're all going to get along famously doing it. So that's not in the notes. I made that part up. So I will now call this meeting to order. Welcome to the continuation of meeting number 14 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of October 1st, 2025, the committee is meeting to continue the clause by clause of Bill C-9 and Act to amend the Criminal Code, hate propaganda, hate crime, and access to religious or cultural places. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using Zoom. I would like to confirm that sound tests were made successfully. Before we continue, I would ask that all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to prevent audio and feedback incidents and to protect the health and safety of the participants, but more important, to our interpreters. You also have a QR code on your desk. You can use that for further information. A few comments for the benefit of witnesses and members. Please wait till I recognize you know all these rules. This meeting number 14 is close to becoming one of the longest meetings in parliamentary history, so you know all the rules. Please wait before you start speaking until you've been recognized by the chair. For those on Zoom, you've got the buttons and translation devices. All comments should be made through the chair. All right, and I'd like to welcome our witnesses back again and thank you for what has been great patience and continues to be great patience, but you are a valuable resource to all members of the committee here. And I know I'm speaking on behalf of everybody. We really appreciate it, so thank you. We have Kristen Alley, who's the manager of Senior Counsel Criminal Law Policy, Joanna Wells, Senior Counsel Criminal Law Policy Section, and Marianne Brees, Counsel Family Law or Criminal Law Policy Section. Okay, so we suspended the meeting on December the 11th, and we were debating Mr. Brock's sub-amendment to Mr. Lawton's amendment, which was CPC 8.1. I still have a speakers list from December the 11th, which I will pick up on. Some of the people who are on that list are not here today. Some are. That's for you, the rest. Okay, and the rest is for me. Okay, all right, so here we go. So I will, just so people know, for people here who's on the speaker list, I have Mr. Jennis, Mr. Fortin, and then Mr. Housefather. Mr. Baber is here, and then I think that's it. Sorry?
What?
Oh, Mr. Lawton, you want on the list. No, I was just going through his. You want on the list. Okay, all right. Okay.
Chair, just point of order. I think some of our regular members, I'd like them to speak before me, so if you don't mind just striking me and putting me to the bottom, I'd appreciate it. Thank you.
Done. Okay, well, that means that Mr. Fortin has the floor.
Just to clarify, Mr. Chairman, when we left off, we were on Mr. Brock's amendment, CPC 8.1. Mr. Chairman, our committee has a lot of work. Important bills are waiting, C14, C9, C16. As far as I'm concerned, we've already lost far too much time, and I'm convinced that everyone around the table would like us to move forward so that by the end of the spring session, we will have gone through all the other important bills which we will need to review. We've already adopted, before Christmas, the amendment moved by the Bloc on religious exemptions for hate speech. And now the motion, which our Conservative colleagues are tabling, are actually contrary to the motion that was adopted. CPC 8.1 says the current article shall not affect freedom of expression or freedom of religion, which is already included in the Charter of Rights and Freedoms, and in no way could our committee say the opposite than what is contained in that charter. What is in the charter will remain. So I don't see what the usefulness is of repeating what is already in a charter. However, Mr. Brock's amendment would replace freedom of expression or freedom of religion with freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication, freedom of peaceful assembly, and freedom of association. This amendment could be interpreted as already existing in the Charter of Rights and Freedoms, or to frame what has already been accomplished by the committee in previous amendments, including the one for religious exceptions contained in the Criminal Code. So I don't see what the usefulness or the relevance is for this amendment, Mr. Chair. I feel that we should not repeat what has already been done, and we have a criminal code which is clear and which is understandable. We do not want to create any legislation that applies to one religious community and have another bill that applies to another one. I like what we've done so far with Bill C-9, and the amendment proposed by our Conservative colleague seems to me useless because we already have these rights enshrined in the Charter of Rights and Freedoms, or it might be an attempt to undermine what was done before, which, in my view, would be deplorable. Thank you, Mr. Chair.
Thank you, Mr. Fortin. Okay, now we have Mr. Housefather.
Very much, Mr. Chair. I appreciate the opportunity to speak. First of all, I want to wish everybody on the committee a Happy New Year, and I look forward to working with all of you on 3 very important justice bills that I think we should all send back to the House as quickly as possible. And certainly I will support sending any bill back to the House in the form that it came to the committee in, if that happens. But what I think we need to do now is try to actually get through C9, which to me is an incredibly important bill. And since this committee
Sorry,
last...
Mr. Housefather, sorry, apparently interpretation is not working, so
Okay.
if you could just hold
Je
on.
vais arrêter. OK. Est-ce que je devrais tester ça? Ou est-ce que je devrais juste faire l'interprétation moi-même, Monsieur le Président? Je peux le faire.
I can speak the other language myself if you want, Mr. Chair. Would that violate union rules?
En anglais ou en français, Monsieur Housefather, je dirais même que je vous encourage à...
Well, Mr. Housefather, I would encourage you to speak French, but to do interpretation, frankly, that's not our job.
Try seeing if it works.
If the English to French was working.
Okay, so testing, is the English to French working? Are you guys getting translation?
La traduction française fonctionne, Monsieur le Président.
It's working?
The French interpretation does work.
All right, so go ahead, Mr. Housefather. Thank you.
Mr. Chair, so since our committee last met, we had a mass shooting at Bondi Beach in Australia. We had 15 people murdered because they were attending a Hanukkah celebration on a beach. It was a tragedy, and I think all members of the committee would join me in sending our thoughts and our prayers to all the people of Australia, and particularly the Jewish community worldwide. that was deeply impacted by this tragedy. And we saw what that shooting caused to happen in Australia, which is that a royal commission has been set up on anti-Semitism, and laws were passed by Parliament on gun control and on hate. And in fact, one of those laws proposed by the government of Australia and eventually adopted by Parliament was similar to things in the Combating Hate Act. And in Canada, we were being proactive. We were trying to pass these laws that police say will give them more tools before such a tragedy could occur, which theoretically could occur anywhere in the world. And there is great danger that tragedies like that could occur in any place in the Western world. We need to do our best to have criminal laws that give police the tools and intelligence services the tools to stop that from happening. And ironically, Mr. Chair, one of the provisions that was contested in the law in Australia was that Australia's Labor government proposed a hate exemption based on religious conviction that was similar to what we currently have in the criminal law in Canada. And ironically enough, the Conservative parties in Australia, the Liberal Party and the National Party, argued that that exemption made the law useless. It's exactly the opposite argument that our colleagues are bringing here in Canada, that are saying that we need this exemption. In Australia, our Conservative Party said the opposite. So, look, I don't think taking out this exemption is a panacea, nor do I think having this exemption to allow somebody who has already promoted hate and charged with promoting hate, having a defense that has never been successful in Canadian history means a lot either. But the claims that have been made, Mr. Chair, and this is why I want to get to the amendment and the sub-amendment, but I want to start with the larger principle. The claims that have been made that people will no longer be able to preach the Bible or the Torah or the Quran or any religious text without being charged with hate speech is absurd and doesn't deserve the credence that is being given to it. I can't even believe these arguments are being made. This was a defense in the law if you have already been charged with the already high threshold of promoting hate against an identifiable group. And then you were able to claim that you did that hate, that horrible hate, based on sincere religious conviction. I don't know of any religion in the country that promotes in their mainstream religion that kind of hate. So taking this out should be not a problem. I don't think it makes a great difference, but it shouldn't be a problem. And I wanted, Mr. Speaker, to put on record the op-ed written by Joseph A. Newberger, who's a criminal lawyer and the chair of the Canadian Jewish Law Association, that was written in the Toronto Sun. So I'm going to read that for the record. Claims that C9, the Combating Hate Act, threatens religious freedom in Canada are false. They are not supported by the bill itself, by the Constitution, or by decades of court decisions. More than that, the claim that Bill C9 undermines religious freedom is not a matter of interpretation or reasonable disagreement. It is misinformation. Religious freedom is explicitly protected by Section 2A of the Canadian Charter of Rights and Freedoms and has been repeatedly affirmed by Canadian courts as a core constitutional guarantee. Nothing in Bill C9 amends, limits, or conditions that protection. The bill does not interfere with worship, belief, religious teachings, sermons, or doctrine. To suggest otherwise is to assert a legal effect that simply does not exist. What is C9? Bill C9 is proposed federal legislation that updates part of the criminal code dealing with hate-motivated conduct, hate propaganda, and the public promotion of terrorism. Its purpose is limited and clear: to address conduct that causes serious harm, including the glorification of terrorist groups and extreme hatred directed at identifiable communities. It does not regulate belief, worship, sermons, or religious teaching. It does not criminalize disagreement or political debate. Religious freedom in Canada is firmly protected by the Charter. That protection is well established and robust. Bill C9 does not weaken it. What the Charter does not protect, because it never has, are threats, intimidation, or the deliberate promotion of violence or terrorism. Canadian constitutional law has always distinguished itself between protected belief and unprotected conduct, and Bill C-9 operates squarely within that settled framework. I write as a criminal lawyer with more than 32 years of experience, and as the chair of the Canadian Jewish Law Association. Since October 7, 2023, we have worked directly with students, professionals, and community members, Jewish and non-Jewish, who have faced harassment, exclusion, and intimidation. We have also contributed to anti-Semitism training for police and are preparing similar work with judges. The pattern is consistent. When hateful conduct is excused or ignored, it escalates. Canadian law already draws a clear line between strong opinions, which are protected, and extreme hatred, which is not. The Supreme Court of Canada made this clear in Regina versus Keekstra, defining hatred as extreme vilification and dehumanization, far removed from criticism or disagreement. Bill C-9 does not lower this threshold, it relies on it. Much of the opposition to the bill rests on a misunderstanding or misrepresentation of free expression and religious liberty. The Charter does not shield conduct that promotes terrorist organizations designated under Canadian law. No democratic society treats the public glorification of terrorism as a protected freedom, religious or otherwise. Another uncomfortable reality is that Canada already has laws to address hate speech, hate crimes, and terrorism, but they are enforced inconsistently. On this, I agree with the author and agree with my Conservative colleagues. That failure has contributed to a loss of civility and restraint, and to the normalization of conduct that targets people based on identity. Jewish Canadians have experienced this acutely, particularly when they are blamed for international events beyond their control, but the consequences affect all communities. Law alone will not eliminate hatred or extremism, but law sets boundaries. It signals what conduct a society will not tolerate. Bill C-9 reflects that responsibility. Bill C-9 provides authorities with additional tools to combat the display of symbols of terrorist entities and will provide additional protections for our most vulnerable religious and educational institutions, including synagogues, schools, and community centers. Bill C-9 is not the only answer to the rise in hate, but it is necessary to not only send a message that hate and anti-Semitism will not be tolerated, but will be prosecuted. I also write as a supporter of political campaigns, including the Conservatives in the last election. And I want to be clear that the real danger is not that religious freedom will be curtailed. The real danger is allowing false claims about religious freedom to obscure the actual purposes and effect of this law, and to prevent Parliament from responding to conduct that undermines safety, dignity, and social cohesion. Read plainly, Bill C-9 respects constitutional freedoms while reaffirming a basic principle. Freedom does not include the right to promote hatred or terror. So, Mr. Chair, I wanted to put that on the record because I believe in C-9 we have a bill that deals with many of the issues that have impacted our communities, particularly my own Jewish community, but other communities in Canada, and will be a positive force to tell law enforcement that we as a federal parliament are sending them a message that we expect the law to be enforced, whether when there are demonstrations in Mr. Baber's riding in Toronto that are entirely unacceptable, that target Jewish communities for absolutely no other reason than they are Jewish, or in other ridings across this country. And I think we all share that objective. So I will now come to the amendment that was proposed by Mr. Lawton and the sub-amendment by Mr. Brock, which I think, again, are misplaced. These are saying that the Charter guarantees in Section 2 remain. Well, obviously the Charter guarantees in Section 2 remain, but they remain for all parts of the bill, not just the subsection where this Charter right is now mentioned. The idea then, to me, would be a complete misinterpretation where somebody could look at this bill and say, oh, does that mean that Parliament intended those charter rights not to apply to the rest of the bill or to other laws where we don't expressly reference that Section 2 rights are protected? It doesn't make any sense because charter rights remain protected. We have not used Section 33 in this bill or anywhere else to remove those rights. And to insert them, I believe, for the first time, in a bill to say that these rights are not undermined or thwarted would then cause doubt in every other bill and every other provision of the bill if we don't repeat the same message. So I would end my remarks, Mr. Chair, because I strongly support this bill. This bill is really important to me, as are the bills on bail and the bills on, giving greater rights to victims and dealing with intimate partner violence. But this bill is really important to me because this bill deals with something that I have requested Parliament do for almost 2 years now in terms of protecting schools and community centers and places of worship and other places occupied by vulnerable communities, and by taking actions against people that carry terrorist symbols in demonstrations. And I don't want to just let this bill go and delay it and cause it to disappear off the parliamentary radar because people are misinterpreting or misleading people about what religious rights are or are not included in this bill. So, Mr. Chair, I'm going to fight for this bill. I'm going to fight hard for this bill. And I'm asking my colleagues, if they disagree, that's fine. Let them vote against the parts of the bill they disagree with. Let them vote against the bill if they want, but let this bill go through clause by clause and come back to the House. Thank you, Mr. Chair.
Thank you, Mr. Housefather. Okay, next we have Mr. Bauer.
And welcome, everyone, and Happy New Year to all of you. Before I defer to my colleague, MP Larry Brock, I'd like to make a couple of comments with respect to not just what my colleague, Mr. Housefather, just said, but in particular with respect to tomorrow, which is when we mark the 81st anniversary of the liberation of Auschwitz. And this mark has been designated by the international community as the International Holocaust Remembrance Day. I'll share a personal story that I've previously shared in the provincial legislature. My family is partially from Ukraine and partially from Russia. And my great-great maternal grandparents were Ukrainian Jews from Odessa. And in October of 1941, Joseph and Rosalia Rosenfeld were executed by the Nazis in the courtyard of their Odessa family home. One of the first things my family did when we first visited the Holy Land is my mom went to the Yad Vashem Museum. It's the Holocaust Museum in Jerusalem, and noted the Rosenfeld's name. For many Jews, like myself, the Holocaust is not just an abstract or a theoretical concept. It's a reality that many in my community deal with for many years, and it's very instructive to us in much of what we do. And not just in terms of the welfare and safety and security of the Jewish people, but the welfare and safety of security of all people. When we read about the horrors of what's transpiring in Iran, with reports this morning in the New York, in one of the New York newspapers, of a credible report of over 35,000 protesters, of 35,000 Persians killed in the last 2 weeks alone, it is horrifying. And that brings me to the point I want to make, is that too often, many in this building, while very well-intentioned, and I want to be very, very clear, I respect all of my colleagues, and I never impute any negative intention when it comes to combating hate or anti-Semitism in particular. But regretfully, I have come to believe, witnessing the events of the last couple of years, that when many use the phrase "never again," they use it more as a platitude. They don't really mean it. And I would say that might be an allegation that may apply to more than one of the recognized parties. Mr. Housefather was correct by mentioning the weekly events in the riding of York Center, specifically my home in North York, about a kilometer from where I live, at the very intersection that my family first dwelled in when we came to Canada, the intersection at Shepherd and Bathurst. And I invite every single member here, every staffer, every official, to come and join me in North York on a Sunday at Shepherd and Bathurst and see what goes on. We're a group of masked men and women. They don't just stand at the northeast corner of the intersection because the police decided that, you know, they're going to segregate both sides. But aside from the fact that they stand at the northeast corner of the intersection, in front of the very building that welcomed me to Canada, and chant incitement to violence every week, chat for intifada every week, encourage people to a violent revolt every week, and seemingly nothing is being done. We had the Director of Legal Services for the NCCM here during hearings on this bill. I think her testimony spoke for itself in terms of the definition of the word intifada and whether she would encourage, you know, some sort of legal action or criminal action with respect to that. This is an organization that received in the last couple of years a considerable amount of money from this Liberal government. We had the Toronto Police. We had the Toronto Police here during the bail hearing who said, look, I'm not sure what the interpretation of the law is. While clearly we all agree that incitement to violence is illegal and that is incitement to violence, but even worse. Every Sunday, they take some time and they walk off Shepherd and Bathurst and they start walking west of Shepherd, on Shepherd, I'm sorry. And sometimes they make a right into the neighborhood of Bathurst Manor, which is where I lived for a number of years and is one of the key neighborhoods that I'm blessed to represent. Probably one of the largest Jewish communities in the country. And these masked thugs, they walk up residential streets next to residential neighborhoods, and they chant incitement to violence, and they're masked. They're clearly denying residents enjoyment of their property. I would suggest respectfully it's at the very least mischief. So I think it's very important as we discuss these things to appreciate that, number one, this is very serious for many of my constituents and Canada's Jewish community that numbers at about 350,000. We're nearing, sorry? 450,000. I appreciate my friend's correction.
Sorry.
There is some disagreement. We are going to mark the International Holocaust Remembrance Day tomorrow, and we're all going to tweet never again. And I would say, I would invite everyone who's unwilling to really implore law enforcement to do the right thing here. Doesn't matter which side of the aisle you're on. My constituents right now are threatened in their homes. To say, no, we are not going to tolerate this. We have existing laws on the book. We insist that the Toronto Police Board, that Mayor Olivia Chow enforce the law and protect Toronto's Jewish community. And that when we say never again, we actually mean never again. I'm very grateful to my colleagues for the deference I received here, and I'm going to defer my time to MP Larry Brock.
Thanks, Mr. Vaber. I had Mr. Lawton and Mr. Brock. You both sort of put your hand up at the first time. I leave it to you two to decide who goes first. Okay, Mr. Brock.
Thank you, Chair. And much like my colleague, Mr. Baber, my colleague, Mr. Housefather, it's good to be back. Thankful that we are here to study three important bills. I trust everyone had a peaceful and relaxing break. I also want to welcome back the department officials. I know this has been a challenging exercise for you. I'm optimistic that 2026 will usher in a fresh approach to how we get things done here at Justice. As I said, when I first accepted the position of Vice Chair, I think it was obviously it was a different chair at that time, Mr. Chair, but I often said my experience has always been one of deep respect for everyone Here at Justice, we deal with extremely important pieces of legislation and policy and tradition, at least from my perspective, going back to September of 2021, has been extremely collaborative. And I'm hoping that that is going to continue. But clearly we're facing an impasse. And it's an impasse that, in my view, should have never come to this. When I listen to the messaging from the government, specifically the messaging from Sean Fraser, Canada's Justice Minister and the Attorney General, he often reflects about the quality of time that he spent engaging with stakeholders, particularly from the Jewish community here in Canada, but other stakeholders, policing, victim advocacy rights, etc., all of which formed, with the direction and the assistance of his department officials, formed the drafting of Bill C-9. And in Bill C-9, as it's currently stated, there was no specific reference to the government intending to remove the religious exemption that has been codified in the Criminal Code of Canada for over 4 decades. No mention at all. No indication in any of the press releases or the technical briefings that parliamentarians receive during the initial debate in the House at second reading. No mention at all from any member of the Liberal Party of Canada that this would be ultimately their stated intention. Now you contrast that to my friend and colleague, Monsieur Fortin, who made it abundantly clear, as did members of the entire Bloc Québécois during debate, but particularly during the meetings that we held on C-9, the witnesses that gave evidence, responded to all questions, and Monsieur Fortin, on a regular and consistent basis, would always seek input from those stakeholders as to their position on the removal of the religious exemption. Now, I may be wrong in this assessment, and if I'm wrong, I will apologize to any particular member of the Liberal Party of Canada, because I've done a number of interviews, I've written a number of articles, I've posted on social media, and if I'm wrong, please correct me. But I don't recall during the meetings that we had on C-9 any particular member, the core Liberal members and their subs from time to time, ever exploring the issue of removing the religious exemption. I could be wrong, but I don't recall that ever being raised by any member of this committee, with the exception of Monsieur Fortin. But then what happened? As we progressed closer and closer to our Christmas break, knowing that we were making progress with respect to clause by clause. But we reached an impasse when we found out, and leaked by the media, that a secretive backroom deal had been brokered by the Liberal Party with the Bloc Québécois to fully support the Bloc's amendment to remove the religious exemption. And critics rightly commented that this was insincere, that this was not about addressing the evils that my colleague Mr. Baber so eloquently and correctly put on record that has been plaguing our country for 2+ years under the auspices of supporting the Palestinian people. So critics said this had all to do with politics as opposed to what is in the best interests of Canadians. And I 100% agree with Mr. Baber's assessment that, I know he didn't use these words, but these are my words, that C9 in its entirety was completely redundant. Redundant in the sense that we've had hate laws codified in the Criminal Code of Canada for over 4 decades. So this was not an issue of police lacking resources, police lacking tools. This was a political decision by various police services on their own or under the direction of their municipal leaders to not do their damn job. And that job, they were sworn to uphold every single law in the 1,000-page Criminal Code of Canada. And example after example, story after story, we have witnessed right across this country examples of criminal activity that should have resulted in charges being laid against these thugs. But they weren't. Inexcusable as to why they weren't. In fact, I'm not going to identify the city. I'm not going to out the municipal leaders. I'm certainly not going to out the provincial, the municipal police service. But examples from that particular municipality rocked me to the core when I learned that the direction given by the municipal leaders to that municipal police service was simply to act as peacekeepers. Sworn, armed peacekeepers, not to make any arrests. And I heard examples in that particular city of threats being uttered, physical assaults taking place, pushing and shoving and spitting at Jewish individuals who simply were there to enjoy their synagogue or to enjoy their place of recreation, free of any abuse and intimidation and harm, and the police dropped the ball. So that's what this issue really is. And I'm glad, Mr. Housefather, you raised the issue of the events in Australia. It rocked the conscience of anyone who deeply cares about this issue. That was a horrific, horrific experience. And I can only surmise that perhaps the uniqueness of Canada's law enforcement not interpreting the criminal code in a black versus white lens, but a gray lens, is what has caused this hate to go unchecked. And when it goes unchecked, Mr. Chair, it emboldens the participants. It gives them immunity. I can scream and call for intifada, as they did at the Eaton Centre on Boxing Day. Not in a public square, in a private business, private center. And again, police were there, and I don't know if there were any arrests, but certainly not enough. Let's put it that way. And that's why the conscience of Canadians were shocked, again, that that was allowed to happen. So I appreciate the passion of everyone's argument, but we also need to remember that we've got 2 other pressing pieces of legislation, 14 and now 16, which is set to today for the first time. But in framing my argument in support of prioritizing 14, I want to reiterate the words of the Prime Minister today in Ottawa. I quote, "From tougher bail, tougher sentencing, protecting younger Canadians from online harm, protecting people who go their place of worship or their community centre, protecting them for harassment, all of that crime legislation is being held up." Not held up by the Conservative Party of Canada, Mr. Chair. And then later, House Leader McKinnon indicates to us, I'm just trying to find the quote. McKinnon says in the House of Commons right now that Pierre Poilievre should support the quick passage of Bill C-14 and C-16. His quote, "It's time for us to put up or shut up on crime." I have been an advocate at this Justice Committee since day one about prioritizing community safety, the safety of Canadians, particularly victims. If the Prime Minister wants us to prioritize C-14, if the House Leader wants us to shut up or put up, I'm prepared, as my Conservative colleagues, also following up on a letter that our leader, Pierre Poilievre, wrote to the Prime Minister, setting out his expectations and priorities and his willingness to work with parliamentarians to prioritize what Canadians want. And what they want is to live in safe communities. I've said this repeatedly till I'll keep saying this till I'm blue in the face. Community safety is not partisan. I don't care what your background, I don't care what your ideology is. Everyone wants to live and raise their families in a law and order community. And we've got an opportunity here as parliamentarians to give them exactly what they want. Therefore, I am moving the following dilatory motion, Mr. Chair, that the committee proceed to the consideration of Bill C-14, the Bail and Sentencing Reform Act, immediately.
Ms. Latanzio?
Yeah. If the motion
haven't
is
heard
in
it yet,
order,
so.
but I would like to respond to the comments being made, that were made by Mr. Brock. So I'd like for you to rule on if the motion is in order.
Okay. Can you read your motion again, please, Mr. Brock?
That the committee proceed to the consideration of Bill C-14, the Bail and Sentencing Reform Act.
Okay, we'll put it to a vote.
Mr. Chair, before it
Sorry,
goes to a
Ms.
vote.
Latanzio, go ahead, yeah.
Thank you. Thank you for ceding the floor to me. First of all, thank you for
Point of order.
your intervention, Mr. Brock, and I also would like to take the opportunity
Sorry,
to
Ms.
wish.
Latanzio, Mr. Lawton's got a point of order.
As I understand, it's a dilatory motion, so there is to be no debate on it before we vote.
You're correct. I was just trying to be, I thought I'd give her a moment to, if it was a point of order type comment, but you're quite right. We have to put it to a vote. So we'll go to a vote.
Can we, Mr. Chair, can I ask for a suspension for a couple of minutes?
Yeah, we'll suspend for a moment.
Thank you.
Brock's dilatory motion.
Madame Latanzer?
No.
Monsieur Housefather?
No.
Madame Dillon?
No.
Mr. Chan?
No.
Mr. Brock?
Mr. Broussard.
Mr. Brassard, pardon.
Yes.
Mr. Barber?
Yes.
Madame Cooley?
Yes.
Mr. Lawton?
Yes.
Mr. Fontaine?
Non.
Okay, Mr. Brock's motion has been defeated.
Mr. Chair,
Latanzio?
I'd like to move a motion and seek unanimous consent to be able to move this motion. Would you like for me to read it?
Yes, please.
Before I read this motion, Mr. Chair, I would just like to make a few comments. We're supporting moving C-14 forward because it is fundamentally about keeping Canadians safe. This bill strengthens our bail system, holds repeat and violent offenders to account, and helps ensure that individuals who pose a real risk are not released back into the communities where they caused and have caused harm. C-14 responds directly to what Canadians have asked us to do. They support victims and gives communities peace of mind. As we move into this new sessions, Canadians also expect Parliament to rise above partisan lines and focus on delivering real results. That doesn't mean that we will always agree on everything, but it does mean that we should look for opportunities to work constructively where we can. Advancing C-14 is one of those opportunities, Mr. Chair, and it reflects shared concerns about safety and accountability. And it's also a chance for parliaments to show that it can act responsibly and decisively for people. This is what the Minister of Justice is seeking. This is what the Prime Minister has said this morning. At the same time, I also want to be clear that C-9 and C-16 are also important pieces of legislation. Our work on those bills continues, and they remain a priority. But when there is a clear opportunity to move forward on legislation such as C-14, that strengthens public safety and reinforces confidence in our justice system, and we should take it. This is about making Parliament work, focusing on the outcomes, focusing and delivering on our responsibility to Canadians. And that is exactly why we will always be in support of moving our own legislation, C-14. And with that, our motion reads as follows.
Ms. Latanzio, you'll need unanimous consent to move the motion first.
Sure.
Before you read the motion. Do we have unanimous consent from Ms. Latanzio to introduce her motion? Yes, okay, you have unanimous consent, so please move the motion.
Thank you, Mr. Chair. So the motion reads as follows, and I will read the English version, that the committee pause clause-by-clause consideration of C-9 and act to amend the Criminal Code, hate propaganda, hate crime, and access to religious or cultural places, that the committee allocate 3 meetings to consideration of C-14, and act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defense Act, bail and sentencing, beginning at its next meeting, Wednesday, that the committee not adjourn its 3rd meeting on C-14 until clause-by-clause consideration of this bill is complete, and that the meeting following the completion of clause-by-clause on C-14, the committee resume clause-by-clause consideration of C-9.
Thank you, Ms. Latanzio. The motion has been circulated to all members in both official languages. Mr. Broussard?
Thank you, Mr. Chair. No comment. I will ask for a recorded vote on Ms. Latanzio's motion, please.
Thank you, Mr. Broussard. Mr. Lawton?
If I could just ask a clarifying question, is it 3 meetings then clause by clause, or 3 meetings and the 3rd resolves into clause by clause?
Please.
3 meetings, including clause by clause, and we will continue clause by clause until we finish the study on C-14, or however long the meeting will take.
Mr. Broussard? All right, sorry, he's done, Mr. Lawton?
Thank you. I would like to move an amendment, and I'm sorry, we just got the motion, so I'm trying to do this in real time. I would propose amending that the committee allocate 3 meetings to consideration of C-14 and act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defense Act beginning at its next meeting. And I would amend that the Minister of Justice, that one of those meetings be dedicated to hearing testimony from the Minister of Justice.
I'm going to suggest we suspend for just 2 minutes so people can
Yep.
absorb what you just said.
Okay.
Monsieur le Président, est-ce qu'on peut avoir une version écrite?
Could we get a written version of Ms. Latanzio's motion? I have it online, but can we get a printed copy?
I just suggested we suspend it for a moment, but the members to my right don't see a need to do that. Mr. Fortin, are you okay with what Mr. Lawton just proposed?
Sorry, but I didn't catch exactly
Okay,
what he
all right.
said, and that's why I asked for a paper motion that we can read and think about without. This is just verbal.
Yeah, okay. Well, let's suspend for a moment and then give you an opportunity and to absorb the motion. All right, we'll suspend. Okay, so we have Ms. Latanzio's motion with, and then Mr. Lawton's amendment. So we'll have to vote on Mr. Lawton's amendment, and then we'll vote on the language of the main motion.
Can you read it in French, please? So, Mr. Fortin? No, I'm fine. I have it. But I do have a question, Mr. Chair. What we're voting on now is to authorize Ms. Latanzio to table her motion and not on the substance on the motion. Is that correct? Unless I'm wrong, and please correct me if I'm wrong, you need unanimous consent for Ms. Latanzio to table her motion. That's already been done. That's been done.
Okay,
Latanzio,
perfect.
To introduce the motion, she tabled the motion.
Okay.
Mr. Lawton then proposed an amendment. So we're going to vote on Mr. Lawton's amendment, and then, assuming that passed, well, regardless, we'll then vote on Ms. Latanzio's
Merci. Merci,
motion.
Monsieur le Président.
Okay. All right, so let's have a vote on Mr. Lawton's amendment. Do you want to read it out again, just so everybody's clear?
Yes, sure. If you give me just 1 second. Okay. Thank you, Mr. Chair. I will go in English and in French. In English, it's inserted after the words "its next meeting," and it would read as follows: and that one of those meetings be the appearance of the Minister of Justice. End of the amendment. And in French, je vais le lire en français. Mais...
In French, the amendment would come after. And that at the meeting following the completion, so just before that, we would have the minister appear at the committee.
We'll go to a vote.
Okay. So on the amendment, Madame Latanzio?
Yes.
Monsieur Housefather?
Yes.
Madame Dillon?
Yes.
Mr. Chang?
Yes.
Mr. Brassard?
Oui.
Mr. Baber?
Yes.
Madame Cody?
Yes.
Mr. Lawton?
Yes.
Monsieur Fortin?
Oui.
10-0, carried.
All right, motion carried. We'll now proceed to vote on the motion as amended.
Motion is amended.
Thank you, Mr. Broussard.
Thank you.
You can sit there anytime you want.
Sorry. OK. Sur la motion telle qu'amendée,
On the motion as amended.
Monsieur Housefather? Oui. Madame Dillon?
Yes.
Monsieur Chang? Oui. Mr. Brassard?
Yes.
Mr. Baber?
Yes.
Madame Cody?
Yes.
Mr. Lawton?
Yes.
Monsieur Fortin?
No.
Okay, motion carried. So that means that on Wednesday of this week, we will proceed to deal with C-14. As such, I will adjourn this meeting. Oh, sorry, just, we don't need to. Any amendments that have to be submitted by Monday at noon. Yeah, now we'll do the gallery.